this time, your lines have been placed on listen only for today's conference until the question and answer portion of our call, at which time you will be prompted to press star 1 on your touch-tone phone. Please ensure that your line is unmuted and please record your name so that I may introduce you to ask your question. I will now turn the conference over to our host, Mr. Patrick Shepard. Sir, you may proceed.
Thank you, Jill. Good afternoon, and welcome to Session 1 of our Post-Employment Massive Open Online class. And this is a course in 3 parts. Today we'll be providing an introduction to the post-employment rule and the first exercise. Tomorrow we'll be debriefing the first exercise and assigning the second. And on Thursday we'll be back to debrief the second exercise. So we do hope you will join us for all 3 sessions. I'm very pleased to be joined today by Cheryl Kane-Piasecki. Welcome, Cheryl.
Thanks very much, Patrick.
So should we get into the deck?
Yeah, actually, before we get into the deck, I just want everybody to make sure that everybody has the appropriate materials that you're going to need for today, and to sort of let you know which of the materials, because we've given you quite a few of them, which of the materials you're going to be needing when, so that you're not sort of trying to negotiate through more materials than you actually need today. For today, what you need is the slide deck. We've given you a copy of the implementing regulation for the criminal statute 18 U.S.C. section 207. We've given you the Federal Register notice version of that because we are going to be making references to various parts of the preamble. The preamble is very rich with additional information that will be terrifically useful in helping you interpret the various key elements of each of the provisions. So if you want to have that handy, I don't know that I'm going to be making specific reference to any of the preambles today, but if you want to use that as sort of the version of 2641 you're going to be using, we are going to be at least looking into 2641 a little bit today. Over and above that, the other materials you're really not going to need until tomorrow and Thursday. So there are 2 exercises and a worksheet to accomplish those exercises, and there are 2 participant guides, which are sort of summaries. They're sort of job aid summaries of the A1, A2, and C provisions, which are more for you to use as reference when you're doing the exercises, but probably even more over when, just for you to have as like a desk reference type of summary of each of the provisions of 207. So now, if we can move into the deck, Patrick, that would be terrific.
Absolutely.
What we're going to do today. If we go down to the next slide, is I want to give you a little bit of a roadmap of what today is going to look like. First and foremost, I want to let everybody know that the course that we're teaching today, or over the next 3 days, is this exact same content that we delivered in 2 different live workshop settings here in Washington, D.C. in the spring. So for those of you who weren't able to attend those live workshops, please know that you're getting the identical content that was delivered in each of those 2 workshops. And also, if you did attend those workshops, be prepared that this is the exact same material.
Yes, this might seem familiar for those folks.
Exactly. So, and you're more than welcome to participate, obviously, but if you were under the misapprehension that this was going to be different content, it will be exactly the same content. And what we're going to do overall over the next 3 days is we're going to be focusing on 3 primary prohibitions in 18 U.S.C. section 207, which is the criminal conflict of interest statute dealing with restrictions on post-government employment activities. Now, you may say, oh, there are more than 3. There are more than 3.
Yes.
There are a total of 7, actually, separate provisions in 207, but we believe that the ones we're going to be covering over the next 3 days are really the ones that you're going to have the greatest need to provide advice on, and that's A1, A2, and C. We're going to be introducing, well, more than introducing, we're actually going to be fully utilizing the implementing regulation at 5 CFR Part 2641. This is a very detailed regulation. It provides an enormous amount of guidance with respect to how to interpret each of the elements of the statute. It has a bounty of examples to help you understand the application of those separate provisions. And as I mentioned before, Patrick, the preamble to 2641 is...
So it's a wealth of information.
Extremely useful additional information over and above what's actually provided in the regulation itself.
We're very fortunate to have both of these. I remember the bad old days before 2641, and applying these provisions was very challenging without the benefit of the definitional information and the implementing guidance. So It's good to have.
It is. It is. And then we're also going to introduce a process. As you're going to see very shortly, or you've experienced probably in your own practice, 207 is, because it has so many different provisions, it's a very complicated statute, or at least on its face appears to be an inordinately complicated statute to try to understand and interpret and provide advice on. And we've found through practice in providing training in this area that it's always really helpful to have like an analytical process that you can use to kind of make sure that you're not missing any relevant elements, but also to kind of keep your mind moving in a particular direction, because it's very easy to kind of get pulled off by a particular element, and then you kind of lose your place in the overall analysis.
It is. It's a complicated law. It takes up as many pages as the rest of the conflict of interest statutes, it seems.
Exactly. So we're gonna give you a process. Now, I am not going to suggest to you that this is the process to end all processes, or this is, singularly, the 7 steps to happiness or anything. This is a process that we've come up with that we're gonna have you use in the context of doing a couple of exercises. And if it's useful for you, then by all means take it and run with it and use it in your own practice. If it's not, then then amend it to suit your tastes. But I do advocate for all of you that you do try to come up with a process, a checklist, something that can help you walk through the various constituent parts of each of the provisions of 207.
Yeah, because I think that's one of those challenges that we face here, as well as a lot of other places when we're providing ethics guidance, is that making sure that our advice is complete and that we've considered all the necessary provisions is in some ways the hard part, and not getting sidetracked while you're trying to accomplish that is challenging. So it's good to have an analytical framework.
It is. And to that end, we're gonna be talking about each of the elements of each of these 3 provisions of the statute. We're gonna have you be able to recognize what those key elements are, and to have you kind of hone in on which ones are most important under what circumstance. Because when you're giving entirely prospective advice to an employee who's leaving government service, and particularly when it's a circumstance where the employee may not be entirely clear on what it is that they think they were going to do post-government employment, we're gonna give you a perspective on how you can best provide the most robust advice to them, notwithstanding that you may have a real paucity of facts. And that's really, so the critical thing is going to be understanding which of the elements are really key in these various circumstances where you have minimal facts, or where you have more facts, or when it's happening once the person's actually left government service. So we're going to try and give you a taste of how you can approach this, irrespective of sort of the post-government status of employees who are coming to ask you for advice.
I find here there's a lot of similarity to a financial disclosure review, where we're providing advice and counseling to employees about an uncertain future. So it's important to share with them sort of trip points and triggers that require them to either get further guidance or to be especially careful, because they might be in a situation where one or more of the provisions would apply.
Exactly, and that's a very good analogy, Patrick. So if we go to the next slide, we are going to be spending all of our time over the next 3 days talking about the statute 18 U.S.C. Section 207. But there are other sources of post-employment restrictions. And we like to alert you to these just so that you are aware that when you're giving post-government employment advice to employees, that you are aware of the other things to which they may be subject, so that you're not limiting yourself just to 207. The first one is 18 U.S.C. Section 203, and I'm going to touch on this lightly, and I'm going to try and give you an actual example of how it would occur, because to explain it otherwise it gets a little sort of convoluted. It's kind of an unintended consequence of 203, because I'm sure many of you are sitting there saying, wait a minute, 18 U.S.C. Section 203 is supposed to apply to like current employees, or but 203 has this squirrely kind of unintended post-employment aspect to it. And let me give you a for instance of how it could actually occur. Let's say that your general counsel at your agency is leaving government service to go join a partnership, a private law partnership. And they're leaving in July. They're going to leave this month. So they've been serving as your general counsel in this, during this year since January. So they're leaving in July. So let's say they go to the general partnership, and at the end of this calendar year, in December of 2015, the general partnership has gotten together, and the partners are trying to determine what partnership share will be based on the profitability of the firm over the last calendar year. 203 comes into play if, for whatever reason, that partnership would elect to share profits that were a result of representational services that they provided before the United States government. So any monies that they got for having provided representational services to a client that were before the United States government, while your general counsel was still general counsel, would implicate 18 U.S.C. Section 203. So in effect, it's kind of an accounting issue for purposes of these partnerships.
Yeah, no, and I think this is, we also see this come up when people are entering government, so it's just important to remember that 203 is sort of the covert or secret revolving door provision, and we must think about it in both instances.
Right. So with 203, again, it's just a matter of informing any employees who might be going out into a post-government employment situation where they might have the opportunity to share in any kind of monies that would be in exchange for representational services, that they understand that they would have to be carved out of any of those monies that were received while they had still been a government employee. An additional restriction is this is the Procurement Integrity Act, 41 U.S.C. 2101 through 2107. And we touched on this a little bit in the Seeking Employment session we did a couple of weeks ago. I'm just going to touch and go here just to remind you that there is a provision in the Procurement Integrity Act which basically prohibits certain government officials for a one-year period after a designated date that's based upon the functions that they have with respect to contracting from receiving compensation from the concerned contractor on a 10 million plus competitively awarded or non-competitively awarded contract. So this is going to reach to some of your contracting officials, people who are involved in procurements, and particularly people who are involved, obviously, in these large procurements. There is this post-government employment prohibition on receipt of compensation from certain sources.
Another case where completeness is important, so if we're talking about an employee who is covered by the Act, we have to remember that it's there.
Exactly. The next one that we want to, some of you have agency-specific restrictions, so this next bullet is about just being aware and cognizant that your agency or department may have restrictions over and above 207 that you would need to counsel them on, and some of them are more onerous than the restrictions in 207. So again, just be aware of whether or not your agency or department has them. The next one is a little I think is striking and surprising to many people who have not heard of this. There is an emoluments clause restriction that continues to extend to retired military officers, enlisted personnel, and reservists. And it basically does not allow them to accept a payment from a foreign government without first obtaining the consent, well, it says the consent of Congress, and in this case it would be they have to get permission by the Secretary of State and the Secretary of whatever military department was concerned. My understanding from this, and again, this is something that if you have a lot of military personnel that you think are going to be affected by this, DoD SOCO, the Standard of Conduct Office at DoD, is in a much better position to provide you with guidance on this. They obviously deal with it much more routinely, and Jeff Green in particular I know has given presentations on this, so call out to Jeff Green. But effectively, my understanding is that it has to do with the recall status of retired military, which is what gives them a continuing position of profit or trust, an office of profit or trust, which makes them subject to these emolument clause restrictions.
Yeah. Another really good thing to remember if we're talking to military personnel about their post-employment restrictions, because we wouldn't want to forget those provisions.
Mm-hmm. In addition, This is why post-employment drives everybody crazy, because it's like add on, add on, add on. But I think this is a reflection, though, Patrick, not to do too much of an aside here, but I think this is a reflection of how important the revolving door is as an ethics issue and continues to be as an ethics issue. And we're still currently even hearing about congressional initiatives to further, restrict particularly financial sector and employees and
yeah, I think it's very challenging both from an advice and counsel perspective, but also from a policy perspective. There's some there's some tension between an employee's ability to move between the government and private employment. We wouldn't want all people to be subject to government employment forever. We know that they're gonna move on, but what is the appropriate level of regulation after they leave? I think it's a challenge we continue to think about.
Exactly. So that's why we have this, sort of like laundry list of post-employment restrictions, because it is an area that seems to be of continuous, concern. And we keep seeing new regulatory, provisions.
It's also very important that we're careful when providing this advice, because these are areas where there is a lot of attention. There's media attention, there's congressional attention, there's attention by stakeholders outside of the government. So the likelihood that there will be questions surrounding a post-employment situation is pretty high, and probably higher than some of the other work that we do. So it is important that we be very careful and complete when advising employees.
Mm-hmm. The next provision that we have to be mindful of is, of course, the Obama administration's ethics pledge. For anyone who is an appointee who has signed the ethics pledge, there are two separate post-employment provisions that will apply to them. Paragraph 4 is basically a 2-year cooling off period, and we're going to talk about this one a little bit more when we talk about 207C, because it's basically taking the restrictions of 207C and extending them for another year. So anybody who's subject to 207C, who signed the ethics pledge, will be subject to those same provisions for an additional year, is effectively what paragraph 4 says. And then paragraph 5 applies to all appointees. So anybody who signed the ethics pledge, my understanding is that they are subject to paragraph 5. And paragraph 5 is a no lobbying covered officials or non-career SES for the remainder of the Obama administration. So that's an anti-lobbying provision. That's also a post-employment restriction. And then finally, we just like to remind people that notwithstanding this whole laundry list of government-imposed post-employment restrictions, certain folks have professional or bar restrictions that they might just need to be reminded to check as well, because that's something where obviously you can't provide advice and counsel in those areas, and they're going to have to go get additional advice and counsel as to whether and to what extent they have restrictions by virtue of those professional responsibility rules. Okay, and we're not quite done, if you can believe it. This one, I don't know how many people are really aware of this one. There is a notification requirement, which is in the personnel regulations. So it's in 5 CFR. So it's in 5 CFR 730. Agencies are required to provide a notification to any employee when they get a personnel action that winds up affecting their coverage under 207C1, which is the 1-year cooling off period for senior employees and the post-employment restrictions. So when somebody enters a position that's going to be subject to 207C by virtue of a personnel action, they're supposed to get some sort of notification informing them that they are now subject to 207C1. And my assumption is, although I would have to go back and double check, but my assumption is that the same would hold true for people who fell out of the 207C realm and are no longer senior employees, that they would also be required to be notified. I think that latter is the case as well, but I know that that definitely when people are assigned to or become appointed to positions where they now are covered by 207C, this notification requirement is relevant.
And this is another opportunity to build that relationship with the Human Resources Office and make sure that this is taking place as it should.
Yes, that is very right. And because you do have to coordinate with your personnel office on this. Okay, so without further ado, what I'm planning to do with you today is I want to give you kind of a broad understanding of the 3 provisions that we're then going to ask you to actually engage in applying once we give you once we set you loose on the exercise. Today is going to be mostly about trying to help you understand the distinction among and between these 3 authorities, and then a little bit better sort of broadly conceptual understanding of what each of these authorities prohibits and how it operates. So to begin with, I want to talk a little bit about one of the key distinctions among and between the 3 authorities is the duration of the prescription, the duration of the prohibition. Under 207A1, we refer to this as our permanent bar or our lifetime ban. Now, Patrick, when we talk about lifetime, what lifetime are we referring to when we're talking about 207A1?
I do not believe we're talking about the natural life of the employee in question, but rather the lifetime of matters upon which the restriction applies for that employee.
Exactly. 207A1 is going to reach to the very matters that employees worked on while they were in government service and create a bar on making communications or appearances back to the government in connection with those very same matters. So when we're talking about permanent bars or lifetime bars, we're talking about permanent bar with respect to the matter, which reaches to the lifetime of any of the matters that the employee worked on. 207A2, by contrast, is a 2-year restriction. Excuse me. Now, A2 is a broader restriction. A2 is going to reach to matters that were pending under a supervisor or a manager's official responsibility, even if they did not, and if they did not work on it personally and substantially. If they worked on the matter themselves, we're going to have
to the A1 ban.
We're going to have an A1 restriction. But A2 is trying to reach to those things that people didn't necessarily touch themselves, but they had under their cognizance that their subordinates may have worked on. And that's a 2-year restriction from the time that the employee terminates service. And then our third one, the restriction gets even broader. And under 207C, now we're reaching to a smaller group of employees. This is going to reach to our senior employees, but it's going to reach to restricting any communication on any matter, whether they ever worked on it, whether it was ever pending in the agency, but any matter in which they're seeking official action. So this is really kind of like a walling off of senior employees from communicating back to their former agencies. So it's a much broader restriction. But as you'll note, the broader, with each of these provisions, they get broader, but then the duration of the restriction is diminished. So it's a mitigating effect. Yeah, the restriction's broader, but it's imposed upon people for a shorter period of time.
And also a smaller universe of people.
Yes.
You can actually see in the progression of these 3 provisions exactly the balancing act that the Congress considered when deciding, how do we mitigate the possibility of misuse of, the authority of someone's position or their former contacts, against the ability of people to move on with their lives after they exit government service.
Exactly. So in terms of employee classification, exactly what Patrick just said. The A1 restriction ostensibly can apply to all employees because it's reaching to employees who participated in certain kinds of matters. And, any employee could at any time, potentially, hypothetically, realistically work on certain kinds of matters that are covered by A1. So we view A1 as being something that anyone working for the government could ostensibly be restricted by. Whereas A2 is going to reach to, again, our supervisory and managerial folks, people who basically have authority to direct government action over other people, people who actually have subordinates under them in an official chain of command. And then our 207C restriction is reaching to this even narrower group of people who are called senior employees. And I want to take a minute to talk a bit about who these senior employees are, because this is actually defined in the statute, and it is something with which you're going to have to become familiar, so that you can put processes and procedures in place to help you identify who your senior employees are. In the first instance, the senior employees are people who are specified explicitly or their pay is fixed according to statutory requirements. So we're looking at 5 USC 5311 through 5318, and if you would go to those statutes, you would see these lists of people, these lists of positions that are specified in that statute, and those would be the positions that would be considered to be senior employees for purposes of 207C.
Yeah, I find those really interesting because they're very specific.
Yes.
These are actual individual positions listed in the statute in some cases. So if you're trying to find out if someone is covered, you can go and see if their position description actually appears on the list in the law.
Exactly. And notice in that first bullet point we say except for 5312. 5312 is level 1 of the executive schedule. And that's an even smaller list. And this is largely your cabinet level people. That's your Secretary of State, Secretary of Treasury. But people in 5312, all of the enumerated positions in 5312 are not senior employees for 207 purposes. They are very senior employees for purposes of 207. And there's a separate provision in 207 that applies to them. And that's 207D. Okay? So you want to make sure that if you look at 5312, those are positions which are going to be subject to the very senior employee restrictions in 207D, not the senior employee restrictions of 207C.
A very important distinction to make. All senior employees are not created equal. There are those people in 5312, which is not a huge universe of folks, but we want to make sure that when we're advising them, we get it right.
Right.
Because they're also the most visible people in the government.
Exactly, exactly. The next bulleted point is really the one I think that how most people encounter senior employees in your agencies. And these are the folks whose rate of basic pay is, and this is where we get into advanced math, which this is a really an interesting example of how legislation gets passed and how strange our world it can be sometime. But so anyway, it's the statutory definition is that they are individuals whose rate of basic pay is equal to or greater than 86.5% of the rate for level 2 of the executive schedule. Okay. So what dollar value is that? And I'm going to come back to this slide in a minute. But on our next slide, anytime that pay rate gets changed, OGE goes out with a notification to let you all know. We calculate this for you, and we send it out on a listserv or in a legal advisory. And for 2015, the magic number for this 86.5% is a nice round $158,554.50.
Yeah, that was so easy we didn't even have to get out the official OGE calculator to get that done. We could just do the math in the head.
So if you have any employees whose rate of basic pay is equal to or greater than this dollar value, then they are going to be senior employees. Now, Patrick, what do we want to make sure people understand about rate of basic pay? And so who this captures and who it does not capture?
Oh, I think it's important to understand it's the rate of basic pay for the position. It's not necessarily the dollar figure that an individual employee takes home each year. So we want to be careful to exclude things like locality pay. You don't, if you move and retain the same position, the same rate of basic pay, and your locality goes up and you cross this threshold, you don't magically become a senior employee.
Right. So locality pay and things like that are carved out of the rate of basic pay. And it's for this reason that's why your GS-15s are not ever going to be senior employees. Because once you carve out locality pay from that pay rate, they're going to drop below this dollar value. So really we are looking at SES and above, or SES equivalent and above when we're looking at senior employees. You're not looking at your general schedule 15 and below. They simply are not going to be, by definition, senior employees.
Right. Likewise, a bonus or something like that would not change the rate of basic pay for the position. So we're looking at the rate of basic pay for the position, not any additional payments that might be sort of coincidental.
Exactly. Now, understand, this isn't just your SES. It's going to be SES equivalents. It's going to be many of you have your own particular hiring authorities where you're allowed to set pay according to certain schedules and or according to certain whatever criteria you've been allowed to use. So there may be folks who you're hiring under those specific authorities that are going to be senior employees because the actual pay that you're giving them, exclusive of locality pay, meets or exceeds this dollar value. So
right, but again, we're looking at the rate of basic pay for the position,
right.
Not sort of the total number of dollars that someone might take home in a year.
Mm-hmm. And for special government employees, for those of you who have special government employees, what you're going to do for them is you're going to try to annualize whatever rate of pay that they're getting. If they're paid, if they're compensated, you'll want to annualize that and see if that meets this dollar threshold. Because SGEs, if they serve more than 60 days, SGEs can be senior employees for purposes of 207C. Okay, so going back up to the prior slide, just to finish out this list. For those folks who have military personnel, for officers, your 07s and above, active duty commissioned officers, are going to be subject to 207C, are going to be considered senior employees. The next two are special appointment authorities that the president and vice president have. So certainly people who are in the executive office of the president would probably have folks who are going to be under one of these two authorities. And then the last one is a newish one. It's assignees who are brought in under the Information Technology Exchange Program. I don't know how many people are participating or how much this is being actually implemented throughout government, but if you have assignees under this program, those folks would also be considered senior employees and would be subject to the bar.
And this might be a place where people would need to reach out to others in their organization, either the Human Resources Office or the technology offices, to see if anyone's being appointed under ITEP.
Mm-hmm. So now we're going down to slide 9, and we'll talk a little bit about the purposes of 207. And Patrick, I like to actually ask folks when we do this live, and so I'm going to ask you all out there, and I'm going to give you a minute to sort of think about it, and then Patrick and I are going to talk about it a little bit, sort of to be thinking about the purposes of 207. We talk about switching sides, for example, and I'm curious, and I'd like you all to think about, like, what do we mean by that? Why do we care? Why is this something that gives us concern such that we think we need to restrict people's ability to do that? So I'd like to give you a minute to think about that, and also sort of this notion of cooling off. Like, what do we think that means, and why do we think it's important to have that as part of our sort of ethics regime? So Patrick, what are your sort of initial thoughts on this?
I've always thought of 207 as implementing restrictions on the use of public office for private gain. Mm-hmm. Even after you've resigned a public office, it's possible to take the knowledge and expertise, experience, contact, etc., that you've gained as a public servant, and there's a danger that you could use those for the private gain of another person improperly. Mm-hmm. And I think that's kind of what 207 tries to do. And in the case of switching sides, our concerns are maybe more numerous. We're mm-hmm. concerned with, using inside information. We're mm-hmm. concerned with also using, contacts that you have within the government, or, preferential treatment that you might have with your colleagues. But we're also concerned with, specific knowledge that you might have gained in the course of your federal work, and not using that for the private gain of someone outside the government. In the case of cooling off, I think it's a little bit different. The idea is just that the position that you had as a more senior or more significant person in the government brings with it some access and some clout that could be put to work for private individuals, and we seek to minimize that harm.
Mm-hmm. Yeah, I think exactly. I think those are beautifully articulated. And with the switching sides, I guess I would only add to that is I think there's an inherent notion of fairness that comes with the switching sides provision. It's this notion that it just seems inherently unfair for an individual, and this seems almost like a loyalty or a disloyalty in aspect to it. For you to be sitting at the table on one side of the table with one group of people representing a certain point of view and advocating for a certain point of view or a certain side, and in the middle of that negotiation or exchange, you get up and go to the other side of the table, and now suddenly you're representing the alternative point of view. You're in an adversarial,
Right.
sort of posture vis-a-vis your prior position, and I think that there's just kind of an inherent sense that that's just really not fair.
Yeah, it feels a little bit like self-dealing.
Yes.
The idea is that, you set this up for yourself and then you leave the government and then reap the benefits.
And I think it's also sort of the level playing field thing, is
Right.
that, if we really purport to have a level playing field for people who are coming seeking benefits from the government, then it almost looks as if you're picking and choosing winners. If you're allowing, that information, the information that the person garnered from being on your side of the table, or any of the influence that came with them being on your side of the table, to basically be extended to just one party and giving them an unfair advantage over other similarly situated parties.
I think that's right, and it's also important to keep that idea of fairness in mind when you're thinking about the significance of our advice under 207. Because the way these things often are detected is that other parties to the matter, or people who would like to be parties to the matter, detect this unfairness and raise the concern, and that initiates an investigation or other enforcement type action. So these are often the ways that these things get detected. If you have an employee who shows up for work for his or her last day on a Friday and shows up at the negotiating table on a Monday on the other side of the table, if there are other parties involved in that, they're going to notice, and they might take action on that.
Mm-hmm. And then with respect to cooling off, I think that's maybe more self-evident sort of aspect to that, which is this notion that, we're all familiar with the notion of sort of influence peddling. And when people are in positions of power and authority, how that they retain that with respect to people over whom they have exercised that authority for a certain period of time. So I think there's this vestigial notion of, once you've been in a position of authority, you retain a little bit of that undue influence over those self-same people, even after you've left sort of the confines of that organization.
But I think this is an area that gives policymakers, a lot of concern, and it's very challenging to regulate. I think there are lots of cases where we say, that kind of feels funny, and we're not sure that should be okay. But it's challenging to kind of quantify those residual effects of public office.
Exactly. So what I encourage you all to do, and one of the reasons why I sort of make us do this thought exercise, is I would encourage you to, for yourself, answer these questions, because I think that one of the things we can tend to lose sight of when we're giving advice to employees is the why. It's explaining to them in a common sort of vernacular what these provisions are attempting to do, why they exist, what our understanding is of why we subject our employees to, frankly, restrictions that extend outside of the range, extend outside the confines of their government employment. This is stuff that's reaching out once they no longer are government employees. So I think we have to be prepared to give them a fairly substantial and, at least hopefully somewhat satisfying explanation for why they are going to be restricted even after they leave government service.
I think that's exactly right.
Excuse me. There is a common misconception I think that folks have, and I think employees have it mostly, is that 207 restricts where they can work. And we sort of debunked this the other week when we were doing the seeking employment provisions as well, which is, no, there's nothing in 207 that prohibits an employee from working for any particular organization. What 207 restricts is what activities they can engage in on behalf of those future employers, but it certainly doesn't restrict necessarily or ipso facto where they can get future or post-government employment. So that was kind of the general overview to give you a feel for the distinctions, the general distinctions among and between the three provisions. Now I'd start to like to get a little bit more into the granular review of the actual elements of 207, A1 and A2. And we're going to start with, on slide 11, this comparison chart of A1 and A2, because I think it's really illustrative, Patrick. I think it's a nice visual to show you just how much A1 and A2 have in common.
No, I think there's really only one element where they diverge, and remembering that can make our lives much easier.
Mm-hmm. So if we look at the elements that are in the middle of our slide there, obviously A1 and A2 are both going to apply to former employees who knowingly make an appearance or a communication with the intent to influence to or before an employee of the United States on behalf of any other person, if the U.S. is a party or has a direct or substantial interest in a particular matter involving specific parties, which is the same particular matter, and here's where A1 and A2 diverge. Under A1, if it's the same particular matter that the employee participated in personally and substantially. So here we're concerned about not allowing communications back to the government in connection with the specific party matters that the employee actually worked on while they were a government employee. And then under A2, it diverges because we're saying, no, we're not concerned about whether or not you worked on it personally and substantially. Here we want to grab all those specific party matters that were pending under your official responsibility, and it's during your last year of government service. And we're gonna cover that a little bit more in a moment, but just so that you understand where the A1 and A2 diverge is really singularly in whether or not the employee actually worked on the matter, or whether or not the employee only had it pending under their official responsibility during their last year of government service.
And I think this is interesting because much like a number of other places in the conflict of interest laws, we find the particular matter, or in this case the particular matter involving specific parties, to be the sort of foundation of our analysis.
Mm-hmm. It is the foundation of our analysis. And what I've highlighted there in red for you, what I think are some of the most critical pieces of 207, A1 and A2, which is 207, A1 and A2 are fundamentally communication bars. That's what they are. And so what they're saying is what you are not allowed to do is post-government employment, you're not allowed to appear or communicate, and it's got to be with the intent to influence, but effectively it's an appearance or communication bar to or before an employee of the United States in connection with these specific party matters that are the same matters you either worked on or had pending under your official responsibility. So we've kind of tried to highlight what really is kind of the nub or the nut of 207, A1, and A2.
Yeah, and I think when we're giving our advice to employees, the facts that we're going to have are the matters that they either participated in personally and substantially or were pending under their official responsibilities. Mm-hmm. And we can sort of begin there and then advise that because you've worked on these matters or these matters were pending under your official responsibility, you can't do the following things. You can't make these kinds of representations.
Exactly. And that is exactly the starting point where we're going to go in our exercises, because the only way you can give really good advice under A1 and A2 is if you know whether the employee participated in any specific party matters, and if they did, what those specific party matters are, because the only restrictions they're going to have under A1 and A2 are going to be relative to those same specific party matters that they worked on or had pending under their official responsibility. So once you know what those matters are or have a good idea what those matters are, then you can proceed to tell the employee, okay, in connection with these things, you may not do the following. So we tried to give you a little bit of a visual representation here, which is to show you that what we're concerned about with A1 and A2 is we want to know, during your federal government employment, did the employee work on any matters that involve specific parties? Okay? Because if they did, then on the post-government employment side, we just have to let them know they cannot represent others back to the government on those very same matters. So
no switching sides, basically.
Yeah, exactly. So this is the switching sides provision. To give you an even more sort of concrete example, let's say that you had an employee who worked at FDA who was engaged in the application, the drug application for Celebrex, okay? After government service, the employee wants to go work for Pfizer. Well, Pfizer happens to be the pharmaceutical company that makes Celebrex. The employee could go work for Pfizer, but the employee could not make a post-employment communication back to FDA in connection with that same Celebrex application that the employee worked on while he or she was at FDA.
So again, we're talking about the nature of the work and the kinds of representations they can make, not where they can work.
Exactly. So that's A1 and A2. When we have you undertake the exercises, we're going to have you working through each of these elements and determining whether these elements are present in the facts that you've been given. And in the debrief of those exercises is where we're going to drill down into each of these elements. So we're not going to talk about the elements in a lot of detail today, but trust me, when we do the debrief, we'll go into a lot more detail about how do you know what a specific party matter is and whether it's the same specific party matter and what constitutes an appearance or communication and when is it to or before an employee of the United States, when is it on behalf of another person. So all of these constituent parts we're going to go into a lot more detail once we debrief the exercise. But for today, I just want to get you familiar with each of the provisions and particularly how these provisions differ.
I think that makes a lot of sense, and I find in my experience with this regulation that these elements are much easier to understand in application than in theory. You can spend a lot of time trying to get your head around the theory, but if you just get in and look at the application, things become a little clearer.
Well, the other thing too is I kind of want I want you to test yourself on how well you understand these concepts before we debrief the exercise, because as Patrick said, it's only in the application where you really are put to the test as to how well do I really understand this concept. And it'll give you an opportunity to ask some really meaningful questions about what each of these concepts means rather than me blathering on and giving you the contents of my head, and much of which probably would be utterly uninteresting and irrelevant to the particular question that you have. So just don't fear or feel like we're not going to cover this in more detail. We are. Today's the overview. Okay, so let's move on to 207C. Now, 207C is our one-year ban, and as we remember, we said 207C applies to this subgroup of senior employees.
For which we have that very long definition.
For which we have that very long definition and laundry list of who qualifies as a senior employee. So here we go. We're going to see some familiar terms here again, even by comparison to what was with the A182. So there's still some familiar terms. The former senior employee may not knowingly make an appearance or communication, that looks the same, with the intent to influence, that's the same. Now here we get a change. To or before an employee of a former agency, okay, where the employee served in any capacity 1 year prior to terminating senior service. So if we go back up and look at A1 and A2, A1 and A2 was you couldn't make an appearance or communication to or before an employee of the United States.
So it's significantly broader. Mm-hmm. A1 and A2 are maybe narrower on the substance or the matter is involved, but they're broader in the category of employees that we are prohibited from communicating with.
Right. So if we go back down to our list on 207C, okay, so a former senior employee is going to have this communication bar with respect to a former agency where they served in any capacity 1 year prior to terminating senior service. Okay, so it's a reach back to their former agencies. Again, on behalf of any other person, that's the same as in A1 and A2. Now it gets broad again. In connection with any matter.
And that's different.
It's very different.
Very different. So we were talking about specific party matters before, and here we're talking about any matter.
Any matter in which the former employee seeks official action. So this is an extremely broad prescription. This is basically saying, if you're looking for anything from your former agency, from a meeting request to a
contract,
that entire universe of everything from a matter, not even have to be a particular matter, a matter to a particular matter involving specific parties. It's the key thing is, are you seeking official action on a matter? And if you're communicating in connection with that, that's what's prohibited for our former senior employees.
So this is the cooling off. Basically, those people you used to work for as a senior employee, you generally shouldn't be talking to them to request anything
Right.
For this 1 year period.
Exactly. It's a cool your jets, stay away, let your former influence sort of wane, and then you can come back and start talking to us again. Now, the interesting thing here that I do want you to note is that the ban, the 207C ban, commences at the end of senior service, not at the end of government service, at the end of senior service. So your 207C restriction is going to commence as soon as the person leaves senior service, even if that's not sort of contemporaneous with leaving government service. So if you have somebody, for example, Patrick, who for whatever reason elects to stay on in government service,
Right.
but they assume a position that no longer makes them a senior employee, then what happens?
I assume we start counting from the time they left that senior position. So this is maybe another case where we're going to have to coordinate with human resources to find out exactly when they left that position. And also it means if we're counseling someone who isn't currently a senior employee, we want to make sure that they haven't been a senior employee in the last year.
Yes. Yes, that's exactly right. So to give you just another visual representation of this on slide 15, whereas before we talked about while you were during your government service, we were concerned about what you did during your government service in order to establish sort of the predicate for A1 and A2. Notice here, we don't have to know at all what the senior employee did during their government service. All we need to know is where they did it. We need to know what the agency was, where they served in any capacity during their 1 year prior to terminating from senior service, because that's the predicate for who they are restricted from communicating with.
So in some ways this is an easier one to advise employees of. We just have to find out where they've served as a senior employee and tell them for 1 year after you cease serving as a senior employee, you basically can't talk to us to ask for anything.
Exactly. Exactly. So with a senior employee, it's simply a matter of going right into what the communication restrictions are and giving them illustrative examples of what would constitute a communication or appearance with the intent to influence. So the post-government restriction, again, is this communication bar. So in the next slide, this is just to sort of familiarize you with the implementing regulation. As I said, when we debrief the exercises, well, actually, as you're doing the exercises, I'm going to ask you to please use the regulation. We've given you those participant guides, which will give you some familiarity with where each of those provisions is located, and certainly to orient yourself, if you want to use the participant guides, I encourage you to do that. But I do think for purposes of really making a determination about whether or not you think that particular element is present, that you do go into the regulation itself, because we will be going into the regulation. If you have the regulation handy, I would like you to sort of pull it out for a minute, because I do want to give you kind of a sensibility about how this thing is structured. I think it's structured in a way that's really friendly to use, and that once you know how it's set up, it'll make it easier for you to actually use.
Yeah, I think the understanding how it's set up is very important. My first encounter with this regulation, I did not think it looked tremendously friendly, but once you understand the logic behind it, it actually is very, very helpful.
If you look at subpart A, that's where your general provisions are, but it's where some of your definitions reside as well. So you want to be mindful that there are going to be definitions in subpart A in 2641.104 that are going to be applicable throughout the regulation, okay? But there are going to be other definitions within each of the separate provisions in subpart B and subpart C. So don't think that your entire universe of definitions is in subpart A, but don't forget to look in subpart A to see which of your meaningful definitions are located there. And the reg is pretty good about referring you back to definitions, but I'm not sure that it's perfect about doing that.
Yeah, and I think this is just like with the standards. We find some general definitions that apply throughout the various provisions in the beginning, and then there are also some definitions that are within the specific prohibitions.
Mm-hmm. But subpart B is where I think it's useful to know how subpart B is structured. Subpart B, sections 201 through 207, are each of the 7 separate substantive provisions of 207. So for our purposes, if you're concerned about A1 and A2, you're going to be looking at 201 and 202, because that's A1 and A2 respectively. For purposes of 207C, you're going to look at section 204, because that's where 207C resides. But the nice thing about each of those sections in turn is that they're all structured sort of identically in terms of the way the information is laid out and the order in which it is laid out. So if you can take a real quick look at 2641.201, if I can find it myself. Getting lost here myself. And what you find with each of these sections is it begins with the prohibition, the sort of general prohibition. And it lays out the prohibition pretty much as that's written in the statute. The next thing is always going to be if there are any exceptions or waivers to that particular prohibition, it's going to directly reference those exceptions and waivers that apply to that prohibition. After that, it's going to talk about, the paragraph C is always going to tell you, when does it commence and how long does it last? Then paragraph D, once you get into paragraph D and beyond, that's where you're going to start getting into breaking out each of the specific elements of the statute and explaining what that particular element means. So in every single subpart, you're going to see the same thing for each of them. You're going to see the basic prohibition, then any exceptions and waivers, then what's the commencement, when does it begin, and how long does it last, and then you'll start getting into the various elements of the statute. Now, obviously, A2 has many things in common with A1, so there are cross-references from A2 to A1. That this has the same meaning or same definition as is found in 2641.201, blah. Okay, but it's useful to know that that's how it's structured, so that you're not sort of figuring out where to look in these for the thing that you're particularly looking for.
Yeah, in subpart B, they're kind of standalone, encapsulated implementing regulations for each of the restrictions, right?
Yes.
So it's kind of contained where we need to look to find interpretation for each of the specific restrictions.
Yes, exactly. Each of those each provision is self-contained in a specific subpart or in a specific section of subpart B.
And I think that does lead to a slightly longer regulation, but a much more user-friendly. There's less flipping back and forth. There's less concern about whether I'm missing something.
Right. Right. And then subpart C, I like everybody to be aware of subpart C and to make reference to it. This is where all of your statutory exceptions and waivers are housed. We are going to be looking at a few of these over the next 2 days. In particular, the first one, 2641.301A, which is the exception for acting on behalf of the United States. This is a much misunderstood exception. And it's a big question that I know folks get a lot of, is when and under what circumstances an employee actually making a communication on behalf of the United States rather than on behalf of a contractor or a third party. And I think looking at that particular exception is particularly useful in helping you understand how limited the universe is of when an employee is deemed to be acting on behalf of the United States. But another really handy-dandy thing in this particular part of the regs is we actually have a table. And if you look at in my book, it's on page 702, but it's at the back of subpart C. It's at the end of 2641.301, and it basically is a table that shows you, for each exception, which of the sections of 207 can avail itself of that particular exception or waiver. So it gives you a real quick and dirty, should I even bother consulting this particular exception or waiver if I'm dealing with an A1 restriction or an A2 restriction or a C restriction. So I just encourage you to sort of peruse subpart C and take a look at that table. That's a really helpful, I think, easy guide. So on the next slide we've given you, this is kind of the process we're going to be following for our A1 and A2 exercise. we want you to start always first with looking at what did the employee work on. So what we're going to be trying to identify first and foremost is, was the employee involved in any specific party matters? And then if they were, did they participate personally and substantially in those matters? Or were they matters that were just pending under their official responsibility? But that's our starting point. And once we have identified those matters, then we're going to go on and we're going to ask ourselves, okay, do we know what the employee is going to do post-government? And if we do, or have some idea what the employee is going to do post-government, is there any possibility that the employee is going to somehow be involved in those same particular matters involving specific parties in which the U.S. is a party or has an interest? So this is another key point, is that, again, the restriction is only going to be on the same specific party matters the employee worked on while a government employee. So the specific party matter has to be the same, and it has to have parties, both at the time the employee worked on it, in their government duties, as well as when they would be engaging in some sort of post-government communication in connection with it. And then finally, once we think that we've identified any specific party matters that may be the same ones, then we can move on to say, okay, now employee, this is actually what your restrictions are going to look like. These are what your restrictions are. Your restrictions are on appearances and communications that would be made with the intent to influence to or before an employee of the U.S. if you're doing it on behalf of any other person. And here's where if we know what the employee is going to be doing, we can help them discern which of their activities is okay and which ones might not be. If we don't know what they're doing, we can still tell them and give them examples of, this is what you might be able to do and this is what you certainly can't do if you're asked to do it. But I think that we don't want to jump into what the restriction is and like what the nature of that's going to look like unless or until we know that the employee actually even has any post-employment restrictions, which we can't determine unless or until we know they actually worked on specific party matters. Okay, so with that, I would like to sort of assign you out your first exercise for tomorrow. If you look, the materials that we gave you, there's one which is titled Ken Dickens. It's called Checklist, and it says Ken Dickens. That's the one we're going to be assigning out to you for tomorrow. Ken Dickens is an employee at a regulatory agency, and what we've given you is a checklist that he would ostensibly have filled out, which is giving you information that you need in order to be able to make a determination about whether or not he has any post-employment restrictions. We've then also given you a worksheet. One of the other handouts that you got was a worksheet. So if we pull out the worksheet, and the worksheet looks like this. I'll show it to you here a little bit better. The front of the worksheet should look like this. So if you pull out your worksheet, the first one is an analysis sheet for a 207A1 or A2 analysis. So what we're going to ask you to do is we're going to ask you to take Ken's facts that he's given you, treat him as if he's one of your employees, and just work your way through this worksheet and determine whether, and try to answer the questions that are on this worksheet, which is effectively walking you through each of those elements that we just discussed.
Right, and the worksheet will help us to make sure our advice is complete and make sure that we're looking in the right place in the regulation to answer those various questions.
Exactly. So it's a check on making sure that you're covering everything, but it's also a useful methodological tool, frankly, for us in doing this training to make sure that we can keep ourselves on track. Because as you're going to see when we do this debrief, and we're going to ask you to robustly ask questions during the actual debrief, it's very easy to get pulled in 2 and 3 and 4 different directions, and then you got to try to find your way back to the path to figure out, to figure out where we left off.
What's the next step? What determinations do we have to make?
Right.
Yep.
So for tomorrow, what we want you to do is to take a shot at looking at Ken's checklist and making a determination about whether he has any post-employment restrictions, and if he does, what those might be. And then the following day, we'll introduce the second exercise tomorrow when we're finished with the debrief, and then we'll debrief that second exercise then on Thursday.
On Thursday. Excellent. So tomorrow we'll be back here to talk about Ken's exercise.
Right.
And we'll be walking through that post-employment analysis worksheet, which we should all take a moment to try and complete.
Right.
If we have questions, we'll be able to talk about those tomorrow. And then we'll have another exercise for Thursday to give us some more practice.
Exactly. So that's our overview for today. If anyone has any questions, you can, for those who are on the Hangout, if you want to post them on the Hangout, and Patrick and I will be very happy to answer them. And if anyone on the phone, Jill, if anyone on the phone has a question, we're happy to entertain questions.
Thank you. At this time, if you would like to ask a question, please press *1 on your touch-tone phone. Please ensure that your line is unmuted, and please record your name when prompted so that I may introduce you to ask your question. Please stand by for questions.
And just a note about tomorrow, I think if people do have questions as they work through the worksheet or with the fact pattern, that it might be a good idea to make a note of those, because
Right.
we'll have a similar opportunity tomorrow to address any questions folks might have.
Mm-hmm.
I'm not showing any questions on the Hangout right
Again,
now.
if you would like to ask a question, please press *1 at this time.
So we'll give folks just another minute or two on the Hangout if they have any questions, and we'll wait on the phone for just a moment more. But if people do have places to go, we look forward to seeing you tomorrow. Please do take an opportunity, if you have one, to go through the exercise. I think this is much more valuable if you take a crack at it yourself. It's much better to figure out what you know and don't know, what you think you know, and then have an opportunity to find out sort of how you did.
Exactly, and I think particularly it'll be useful for us to know how to focus our discussion tomorrow, because believe me, when we've offered this course in the past, it can last an entire day. Given all of the various and sundry elements that you work through, it can last a really long time. So I would prefer to be able to hone in on the aspects that you are uncertain about or that you find particularly difficult, and that way we can make the best use of your time.
Yeah. Do we have any questions, Jill?
We have no questions at this time.
Okay.
Excellent. And we're not showing any questions on the Hangout. So again, please do take a crack at the exercise, and please do join us tomorrow at 12:30 Eastern Time. We'll be sending out the information for connecting tomorrow as well. Thanks very much for joining us, Cheryl, and I look forward to being back here tomorrow.
And me too. Thanks very much.
Excellent. Thank you.